Well, hello, everyone who's joined. Thank you for joining. My name's Paul England, and the point of this short session is to do some gazing into the not too distant future, I think, at an issue or issues that, I'm quite sure come to the court fairly soon. And in fact, I can tell you it's something we've already advised at least one patent owner on. And I've titled this second patent for precision medicines, challenges of validity and enforcement. But what I'm addressing in particular is a type of purpose-limited patent claim, which you could equally call a subpopulation or personalized medicine claim, all labels for essentially the same thing in this session. And these raise issues of validity, especially novelty, as well as enforcement, all of which are unresolved by the courts, but will have to be resolved. So these patents are, these patent claims have heard drugs that are particularly effective at treating a subpopulation within a group of patients with a disease, particularly effective because that subpopulation shares a predictive biomarker for that disease, by which I mean a distinctive protein or gene. And there's a causal link between the role of the biomarker and the action of the drug. And at the extreme, of course, the drug might be suitable for just a very small group of patients. Theoretically, could be just a few people. So I'll give you an example on this slide. And that's Gefitinib, which I've pictured. And Gefitinib originally failed to show significant benefits in an overall population of patients with lung cancer in a phase 3 clinical study, I think it was. And as a result, it couldn't get European approval, and for the world appeared to be a failure. But it was later discovered that a subpopulation of about 10 to 15% of lung cancer patients, that is those having tumors with a mutation in the epidermal growth factor receptor for tyrosine kinase, the EGFR-TK, responded particularly well to the drug. And that's because Gefitinib inhibits the EGFR-TK activity that promotes the growth of certain lung cancer cells. But these beneficial effects in this group had basically been masked in the original trials of the whole disease group by the clinical responses of those, or lack of clinical response, and side effects, in fact, of those who didn't have the mutation. So subsequently, Gefitinib was granted a marketing authorization for the treatment of adults with locally advanced or metastatic non-small cell lung cancer who present positive for mutations of EGFR-TK. So Gefitinib is quite an early example, to be fair, but I'm sure you can see that as AI develops in combination with large amounts of data on individual genomes, clearly more and more work is going to be done and is being done on finding predictive biomarkers and drug treatments associated with them, including the reuse of old classes of drugs, some that have been used before ineffectively for the very same indication. Now, patent claims of the kind X, very broadly, X for the treatment of Y in individuals with biomarker Z that you would need to draft to protect this kind of treatment are actually being granted by the EPO. But the question is, would they be valid in the UK if challenged? And specifically, how can it be possible to patent the same drug for the same treatment in a smaller group of the same people? Where's the novelty in that kind of patent? Isn't use in the subpopulation inherent in use for the wider population? Looking at the EPO first, the case law of the Boards of Appeal appeared for a while at least to actually regard inherency of that kind as a problem for the novelty of these kinds of claims, with the treatment or diagnosis of the same condition with the same compound only held novel if applied to a new group of subjects distinguished by physiological or pathological status that doesn't overlap with the group previously treated. But in more recent cases, though, claims for treatment of defined subpopulations by the same compound of the same disease have been held novel by the TBA, regardless of any overlap. For example, TNF-alpha inhibitor, P73412. Now, in that case, a claim to the treatment of autoimmune disease in patients with an inadequate response to TNF-alpha inhibitor, quote, using rituximab, which is the anti-TNF-alpha antibody, was held to be novel. And the physiological or pathological feature, the predictive biomarker, shared by the subpopulation, which was some 30 to 40% of the whole population, which distinguished it from the wider population, was increased Th17 cell numbers and IL-17 expression levels, which responded to rituximab. And the claim was held novel despite the treatment of rheumatoid arthritis patients in general by rituximab being known before the priority date. And it seems that the reasoning allowing these patents in the EPO appears based on, at least in part, on the decision in an old decision in mobile oil friction reducing additives, which owes nothing to life sciences. But it's nonetheless important because the mobile case concerns patents the inherent but previously unknown friction reducing properties of an additive to engine oil. And the use of the additive before the priority date of the patent was for reduction of rust. But it also, it would also have had the unknown but inherent effect of reducing friction in an engine at the same time, which wasn't known. So the Enlarged Board of Appeal allowed the patent on the basis that the hidden or secret friction reducing properties, not previously having been made available to the public, didn't anticipate the claims of the patent. That is, didn't destroy novelty. Now, the problem in the UK at the moment is that there has been no decision directly addressing the issue of these kinds of precision medicine claims. And whilst the UK courts might follow the Boards of Appeal of the EPO, and they often do when there's a lacuna in the English law, and they may do that in a future case, but there's no guarantee of that. And in particular, the courts can be expected to examine the words of claims very carefully in each case. We also know that English judges, for example, Floyd J, as he was at the time in Actavis UK Limited, and Janssen, not being entirely convinced about the reasoning in Mobile. And Floyd says, and I quote, in that case, if Mobile is correctly decided, if he says it's correctly decided, then unadvertised technical effects which underlie new uses of known materials are an exception to the normal rule about inventive results. And he doesn't have to decide the point in that case, but he's a little bit equivocal about whether such a claim would be allowed. But there's a further consideration that arises from Actavis and Janssen, and this is the objection that novelty cannot lie in a new explanation of the mechanism of an old use. And in this case, Actavis sought a revocation of Janssen's European patent concerning the stereochemistry of an important blood pressure lowering drug, nebivolol. The relevant part of Claim 1 of the patent is in Swiss form, and on the slide, it's used for the manufacture of a medicament for potentiating the effects of blood pressure reducing agents having adrenergic and or vasodilating activity, compound of the Formula One. And the question was whether this claim, in particular the feature of potentiating activity, was inherently anticipated by the use in the prior art of compound falling with the claim for the same purpose, but without the disclosure of that potentiating activity. And Floyd J concludes this. He says, in my judgment, merely explaining the mechanism which underlies a use already described in the prior art cannot, without more, give rise to novelty. In mobile, the technical effects which underlay the new and old uses are different and distinct. It is not the case that every discovery about the mode of action of a drug can be translated into a new purpose and claimed as such. So as a result, the difference between claiming an old use of a drug for a subpopulation with a newly disclosed biomarker on the one hand and a claim to a new explanation for the mechanism of an old use on the other may not always be clear. And the crucial difference between the two kinds of claim appears to be, and this is the way I read it, that the latter provides a new technical contribution by disclosing a physiological or pathological characteristic, that is the biomarker, that may be targeted to produce improved treatment. But for the former unpatentable kind, they merely provide information on the causal relationship that makes what is already known work. So, whilst I think the UK is probably going to follow the EPO approach to precision or subpopulation claims proper, in practice, it's going to be difficult. I think care is going to need to be taken to distinguish between these and claims to a mechanism a mechanism explaining an old use. And some cases will no doubt fall on the wrong side of the line. But there's another issue, and this one the TBA doesn't, of course, have to worry about, which is enforcement. So what about that? Well, unfortunately, it's probably more difficult. Let's think first, before looking at subpopulation claims, let's think first about what we know about second medical use claims on this. For those types of claims, the enforcement issue is this. When patent protection of the underlying active ingredient has expired, how can a second medical use patentee prevent a generic version of the drug finding its way onto the market to the patented indication, either deliberately or accidentally? And conversely, of course, the question is, how does a generic or biosimilar company supply the drug for the legitimate, unpatented use with the confidence that it won't be sued for infringing use? And they have, as I say, been very difficult questions for the court to resolve. And as a consequence, the Warner-Lambert and Actavis case, in which it was a major issue, went all the way to the Supreme Court. And some of you, I'm sure, are familiar with the facts of that case, but I'll give you a very quick recap. Actavis were marketing a generic pregabalin product under the brand name Laycont, which was launched in February 2015. And Laycont is marketed under a skinny label. In this case, the SMPC and the patient information leaflet included in the packet stated that the conditions for which Laycont is indicated are epilepsy and generalized anxiety disorder only, indications which patent protection had expired. But Warner-Lambert owned a patent which the relevant claims are drafted to pregabalin for pain and, in particular, neuropathic pain. They're actually drafted in Swiss form. And as a result, despite the treatment of pain being carved out on the skinny label, Warner-Lambert claimed against Actavis for infringement of their claims. And the issue before the Supreme Court was what was meant by the word for in second medical use Swiss form claim, and what, if any, mental element does that require of the manufacturer? And at first instance, Arnold J. held the word for requires a subjective intention on part of the manufacturer. And the Court of Appeal didn't agree and held that the word for requires the third-party manufacturer to at least be able to reasonably foresee the ultimate intentional use of the infringing purpose by an end user, which is an objective test rather than a subjective one. As a good measure, the Court of Appeal threw in a defence for the manufacturer that would apply when all reasonable steps have been taken to prevent the generic product being used to treat a patented indication. But the Supreme Court decision on this was split 2-1, because while 2 of the judges thought the word for did import a subjective intention, 2 judges, Lord Assumption and Reed, with the qualified support of a 3rd judge, put forward a new approach, which they called the outward presentation test. And all of the judges agreed that the foreseeability test was inappropriate. So I won't go through the reasoning of all of those. I just want to jump to the outward presentation test, which is by a small margin what we're left with. And according to the outward presentation test, whether there's infringement by a generic turns on their intention and the badge of that intention in the physical characteristics of the product, including its formulation, dosage, packaging, and labeling, including the skinny label, and the patient information leaflet, which conditions for whose treatment the product is intended are identified. In other words, if these show the product is designed for the patented purpose, that is evidence of infringement. So I just want to round up, because I'm on my at the end of my time. Very quickly canter through the problems and solutions here. So just note that the claims at issue in Warner Lambert were in the Swift form for start, technically a process claim rather than the EPC 2000 form. So even before trying to adapt this decision to subpopulation claims, the issues raised whether the Supreme Court's analysis is even universal for medical use claims. But then you have to grapple again with the problem of how to demonstrate that a personalised claim has been infringed by a generic, and it's being sold legitimately for the indication for the whole population anyway. And the outward presentation test in the Warner-Lambert decision would suggest it's a matter of whether there are different dosage sizes and regimes for the subpopulation. But there's no carve-out possible for the subpopulation in the same way that there is for indications on a skinny label. And even if there were, how would it work? How can it be an answer to carve out certain pathological features from the label when even the patient may not know they have them? Another solution would be a regulatory change to prescribing practice, but the medical profession can be, I think it's fair to say, reluctant to alter its practice to accommodate pharmaceutical companies. They may see that as a factor on their freedom to prescribe. And even assuming this question is resolved, there's the same problem faced with infringement of second medical use claims. How do you selectively injunct the infringing use? And you can't, an answer isn't to license it, because English courts have demonstrated numerous times, even recently, that they don't like compulsory licenses, except in uniquely life-saving treatment. So I think alternatively, just try and end very quickly on the practical note. I think until this is resolved, we're probably going to have to go back to what was the situation in the earlier 2 cases, where if a party is particularly worried about this issue, they have to look into writing letters to doctors and pharmacies and taking other steps, all the steps they can reasonably take to warn off pharmacies and doctor practices and the NHS about the indications that their drug is for, but rather that it's for people who haven't been diagnosed with the biomarker. I think that's where we're at on that at the moment. As you can see, it's obviously a very complex problem.